Well, um, good morning, everybody. Welcome. Thank you for your interest in attending to this webinar, who is one of the annual webinars about the evolution, the modern evolution of family law. And at this year, we have the webinar Family Law Answers to New Situations. As I told, thank you for attending this webinar. We appreciate it very much. And today's society is evolving and giving rise to situations, and now some decades ago, some sex unions, new types of relations and parentage, surrogacy, etc. So family law has responded to this evolution and these new situations in various ways. As I told, as part of the annual webinar series in which the ELI Family and Succession Law SIG studies the latest developments in family law, this webinar will focus on some of the answers from family law to these new social situations. Thus, today, over two parts of sessions, we will examine the determination of the applicable law, specifically in cases of matrimonial property, parentage based on intention, the protection of the economically weaker party in same-sex unions, the significance of the latest reform of family law in Germany, gender-based domestic violence, and the impact of algorithms and AI on family law. We hope you find it interesting. As I told, the webinar will be divided into two sessions, which will be chaired by Elena Bargelli, who is presently at this time. She is present at this time, who is the is full professor at the University of Pisa, and she's one of the co-chairs of the SIG. And second two, will be chaired by Gregor Christel, who is full professor at the University of Graz, and the co-chair of the SIG, namely the chair of the sub SIG about succession law. I thank them for participating in this webinar. And I'm not going to be more lasting, and I give the floor to Elena Bargelli to chair the session first. Thank you.
Thank you very much, Francisco. Good morning also from my side, and welcome to the webinar Family Law Answers to New Situations, organized specifically by Francisco Javier Jimenez as co-chair of the ELI Family and Succession Law Special Interest Group. Three speakers are scheduled for the first session of today's webinar: Sharon Shagarki, Virginia Zambrano, and Roberta Marino, whom I warmly welcome. The first speaker is Sharon Shagarki. Hi, Sharon. Who is a full professor of private, international, and interreligious law at the University of Jerusalem. Her main areas of interest are conflict of law, family law, and comparative law. This morning, Sharon will speak about whose law is it anyway, the case of matrimonial property. Please, Sharon, the floor is yours.
Hi, thank you very much for this kind invitation and introduction. So the paper I'm going to present, you can see my slides, right?
Yes,
Yeah?
yes.
Okay, good. Thank you. Okay, so the paper I'm going to present, it's not a new paper, but it's been ongoing, so I want to discuss it a little bit with you. It's a paper based on some empirical research I did regarding matrimonial property cases in Israel. It is part of my bigger project that deals with the acceptance and the practice of PIL, and especially conflict of laws in reality, which I think we discuss it a lot. It's very interesting, but in practice, it is maybe too complicated or too pricey, or it just doesn't really work that well. So I started by examining this question with matrimonial property. And I think that something is gone wrong with choice of law generally and choice of law in matrimonial property in Israel specifically. And for the latter part, I think I can somewhat show this in this research. So my hypothesis is that judges don't want to use foreign law because it's complex, because of accessibility, because of costs. And it might be that all players involved try to get rid of foreign law and choice of law. So it's not only judges, it's also lawyers, parties, legislators, maybe scholars as well. So this is the general background of this project. The project itself, so as I will show in a minute, in a very unusual way, Israel has two choice of law rules, unofficially, but two choice of law rules for matrimonial property. And I was trying to see how the judges choose between the two laws, because I thought this is a good laboratory to see their motivations. They have two options and they get to choose between them, and we can learn something from the way they choose it. So my methodology was I took all of the cases that were published. Of course, these are family law cases, so most of them are not published. But so I had 30 decisions from all over the years, so it's really not a big group, which is why I will give you numbers, but I don't argue these are statistical outcomes. I say they reflect some tendencies, but I don't know anything statistical. But what I can already tell you is that I've continued this project and I've looked at a much bigger sample of cases that I get from the courts, but those are not selected. So it's the full year of the cases I look into. And there I see that I cannot still give you numbers, but I see that the same trends are valid. So even though I don't argue for anything statistical, I think there is some truth that we can learn from this project. Okay. So here are the two choice of law rules we have in Israel. So the first one, which is the official rule, it's in the law. And it says that the financial relationship between parties will be governed by the law of the domicile of the parties at the time of marriage. And they can change it by an agreement if they wish to. But then about 20 years after a bit more, 25 years after the legislation of this act, there was this famous case called Nafisi. And this was a couple who came from Iran. They moved immediately before the revolution, or just after. They moved to Israel, and then they had the matrimonial property question in Israel. And there the judges said that Section 15 generally applies, but various circumstances in the life of the parties may be construed as an agreement, which, as you can see, it's not what the law says, but the court decided that it is still okay to create an agreement this way, and then the applicable law changes. So, for example, if they immigrated somewhere, then maybe the law of the place where they immigrated might be the applicable law. So, as we can see, two distinctly different rules. One is very clear, one has a lot of discretion, and the judges can choose between the two laws or two rules, and I was looking to see why, or how did they make the choice. So what did the courts do? It is clear that the courts knew of Section 15, because my first assumption was maybe they don't know. So they know in 93% of the cases they mentioned it directly. And the other 3.5% of cases described it without explicitly referencing Section 15. So I think they know about it. It's not that they don't know. When they don't apply it, it's not because they don't know. But they still don't apply it because only 40% of cases applied Section 15. So the majority applies something else, which is the court decision and not the law, even though they are aware of the law. Sorry. Yeah, okay. So now my first assumption was, of course, this is all about Lex Fori. They use the law that they can to apply their own law. So if Section 15 would get them to Israeli law, they would apply that. If they cannot, they will try Nafisi to get to Section 15. And of course, this is a very well-known argument in private international law theory that judges want their own law. So I thought maybe they were using the choice between the laws to or the choice between the rules to decide which law to apply. But I was very surprised to find out that this was not the case. So I did the whole research with this hypothesis. I got to the outcomes. The outcomes did not work. So foreign law was indeed applied in almost half of the cases. So if you were trying to avoid foreign law, this probably is not the way. In some of the cases, they used Section 15 to get to Israeli law, but in many cases, they used Nafisi and also got to foreign law. So there's no correlation between the rule you use and the law that you get out of it. So Nafisi was not a tool to avoid foreign law and apply Lex Fori. At least in my sample, it seems that Lex Fori is not the issue. So what can be the issue? So I looked at a list of questions that we might think might motivate a judge. If they're looking at the outcome, they might choose this law to get to this outcome. So maybe they want to be better with plaintiffs or respondents. Maybe they have gender preferences. Maybe it's class preferences. So they want to help weaker parties, for example. Maybe they want agreements and they try to uphold agreements. Maybe it's the applicable law. So if the law is from a friendly nation, we apply it. If it's an unfriendly law, we do not apply it. Or maybe just the judges like this or that. And maybe I can see that this judge likes this for no reason, and this is why they do it. Okay. So I see some trends. So for example, there is some preference for plaintiffs. As we can see, plaintiffs won a little bit more than 50% of cases, which is more than the normal statistics, because of course the burden of proof is against plaintiffs. And then the Nafisi rule was generally more prevalent in the corpus, but still plaintiffs only lost in 27% of Nafisi cases. So we see correlation between the Nafisi rule and winning of plaintiffs. So it's more than 50% when they apply Nafisi, but it's not a very big number. I remind you that the corpus itself is only 30 cases. We cannot learn anything from this, really. So also the same for gender. We see 60% of cases where women won. And again, here, the majority of cases where women won involved Nafisi, but still not enough to say anything. And the same for class. So we see that in the majority of cases involving lower classes were using the Nafisi rule. But again, so this is a bit clearer. The numbers are a bit bigger, but still I don't know enough. So there's some tendency. The same for some indication. So as I show all of the 6 questions I have, there is some connection between the rule and the outcome. So the same for unfriendly or non-Western nations. Foreign law was used in 75% of cases involving Western nations. But Nafisi was rarely used in these cases. And Section 15 was never involved in a case involving non-friendly countries. So again, some correlation, not a lot. The same for limited respect for nuptial agreements, and the same for personal judicial preference. And I will go into this a little bit. So 40% of the decisions were given by judges that were reoccurring. So even though it's going through many years, but the cases that are published are usually cases where the judge wanted to publish his decision or her decision. And so it's usually the same person who wants their decision to be published. So even though it's very few cases, we may still get the same judge over and over. And indeed, 40% of the cases were judges that gave more than one decision. But they all but one used both rules. So I cannot say that this judge prefers this one or that one. It also proves that they are aware of both rules and they have some system of choosing between them. I just don't know the system yet. Okay. So I think this does not reflect the whole story. First of all, because there's some collapse of reasons together or accumulation of reasons. So, for example, with a preference to the plaintiff, so I can see that plaintiff, gender preference, and poverty merge. Usually the plaintiffs are women, so the men hold the money and the women want the money when they separate. And in 90% of these cases, she was also the party who's asking for the property to be divided. So it's the same. So gender and plaintiff and poverty merge together. With the unfriendly nations, all of the cases where unfriendly nations were involved, it was also that the unfriendly nations used a regime of separation. So I don't know if it's because we don't like this country or because we don't like their law. And many of the disregarded agreements also mandated separation. So here I start to see something, that there is some correlation between separation and rejecting the law. I don't know why they rejected, but I think maybe separation has to do with it. And then I see that in 63% of the decisions, the outcome was sharing. And in most sharing decisions, Nafisi rule was involved. So I see that there's something about sharing and division, and this gives me a hint to the solution. So here's my big picture argument. And this took a while to understand, but in substantive law in Israel, we do have two matrimonial property regimes, which is again not very usual, but this is what we have. Sorry, so for married people, married and after 1973, they have a delayed limited community of assets, but the courts don't like this regime. Even though the legislature did it, the courts like what they had before, which is a complete community property regime. And so the courts within local cases, they reject usually, or they amend, but not really amend. They change the law to mean community property. And so it is not surprising that they do the same for cross-border cases. So here my argument is that the judges don't use lex fori. Yes, this argument was, I think, revoked. We see that it is not true. But they also don't choose very neutrally. What they do is they have a lex nostra. So it's not lex fori, it's lex nostra, the law that they like, and they ignore basically both rules, or they use both rules only to get the outcome they want. So my finding of matrimonial property is that judges have a hunch or a feeling about what the outcome should be, and this is the outcome they get to. And then choice of law is just, yeah, they go through the motions, they do it if they have to, but really what they want to do is to ignore agreements that forbid sharing. They want to ignore laws that forbid sharing, and they want to create as much sharing as possible. So in one case, I saw them interpreting French law in a way that is completely not true for French law, to say that French law is about sharing. In another case, I saw them creating an agreement that really was not there to create sharing. So I think this is the outcome. So if I go back to my BRIC project, I think that judges indeed have some aversion maybe to choice of law, but not because of the reasons maybe we used to think, but because of other reasons, namely that judges want the justice that they understand. And if choice of law is in their way, then choice of law has to go away. Thank you. This is it for me.
Thank you very much, Sharon. Very interesting presentation. Well, the floor is now for Virginia Zambrano, who is a full professor of private comparative law at the University of Salerno, where she teaches intercultural law, private law, and sports law. Please, Virginia, the floor is yours, and if there are questions regarding each presentation, the discussion may be held at the end of the session if there is still some time left.
Okay. Thank you, President. Thank you to Javier, of course, to Elena, and to all participants, and thank you very much for the invitation. Now, it has always been difficult to establish who would be considered a father, at least until the biological test was introduced, due to the failure of being aware of the father's identity. Now, while the mother semper certa principle, albeit obscured in France, in Italy, and of course in Germany, by the possibility of not being named on the birth certificate, makes the issue of establishing maternity less ambiguous, the situation is quite different for paternity. It is a problem that in The Merchant of Venice emerged clearly from the dialogue between Lancelot and the old hunchback. Words revealing how the need and difficulties to establish a criterion capable of dispelling all doubt regarding the identification of the father has always been felt, with biological tests still a long way off. Shakespeare gave the task of revealing the truth to chance, to people's consciousness, and to society. Later, as everybody knows, with the Code Napoleon, this problem found a solution in marriage. Now, the presumption of husband paternity emerged as a public order rule to safeguard the need of protecting family integrity, as well, of course, as the child. The legitimacy approach was, in a way, the product of very rigid principles which were adopted by legislators to protect a so-called family order. Now, filiation rules on this basis historically developed around three main strands, which are now in a dialectical crisis: presumption of paternity and possession of status, biological genetic truth, will, as it is the case for adoption and the acknowledgement of paternity. This basic framework must now be combined with a different approach, as everybody knows, to the relational dimension of parentage and to the need of protecting the child's interest. The growing emphasis of human dignity, non-discrimination principle, and respect for privacy, together with the emergence of different family models, has opened up now a new chapter in the area of affiliation, which is able to let me say, modify the traditional rules for determining filiation, as the question raised by the assisted reproduction techniques clearly prove. Now, in the background, what we can see a family model which is no longer built around the couple, but open up to multiple parenthood based on responsibility and on the parental project, and hence imbued of relationality. As an attentive Canadian, actually British Canadian legislator has not failed to grasp with regard to filiation, the legislator of the British Columbia allows for the legal recognition of more than two parents if it is established by written agreement and reflects the reality of the family. Driven by the wind of change toward a social parenthood based on parental project, the crisis of presumption of filiation is evident in all European legal systems. This is the case in Spain. The growing space recognized to the will can be perceived within the ratio decidendi of a case law, and are mainly decisions of the audiencias provinciales, where attention is paid by judges both to the intention and to a parental project. Now, what is interesting to observe is that case law is concerned, on the one hand, with the need to safeguard the right to know one's biological identity, and on the other, with the development of reproductive techniques that weaken that right, calling for new rules on filiation. Awareness of this change in family relationship is, let me say, encapsulated in the explanatory memorandum to the ley trans, which amended the Article 120 of the Spanish Civil Code, thus identifying a new criterion for determining non-marital filiation alongside with those already provided for. In this voluntary approach, the significant factor is therefore the existencia de un progetto riproduttivo in común. Thus, when this project is lacking, as was the case in a very interesting case decided by the Supremo Tribunal in 2023, neither the possession of status nor the reference to the interest of the child are of any relevance. Now, in that case, the claimant filed a dual paternity suit to determine, on the one hand, that he was the father of the two biological children of his male partner, whose paternity was registered in the civil registry, and on the other hand, the claimant also requested that his former partner be considered the non-marital father of the claimant's two biological children, whose paternity was registered, of course, in the civil register. In the two instances, this claim was dismissed due to the fact that the claimant had not proved that he was the biological father of the two children. Now, in line with this demand for modernization and equality, a very good example comes, I don't know, I would be very interested in hearing the speaker talking about the German reform. The German legal system has embarked on a process of making filiation law even more flexible, leading recently after the Kinderschaftsreformgesetz of 1997 to a new modernization of the filiation. Now, with the reform of paragraph 1626 and 1671, priority was given to the emotional dimension of family life. This falls beyond the traditional view of the family, as well as its purely biological dimension. Therefore, the resulting tension in case law between biological truth, will, and legal stability has led to ongoing cooperation between judges and legislators in order to provide for a legal framework for these changes. The reference to the Kindeswohl allowed the judge to strike a balance between the interest of the child and the voluntary dimension in a context aimed at establishing the legal relationship. Two key case law illustrate such a shift. The recognition of the right of access of the Umgangsrecht of the leiblichen Vaterschaft, even when he had consented to the adoption, if the relationship with the child has been consolidated. This is a decision 2021 of the Bundesgerichtshof. And in this case, the Bundesgerichtshof emphasized that the facto relationship regardless of formal consent to the adoption is very important. And in case, second example, in cases of Leihmutterschaft, German case law allows the transcription of a foreign birth certificate in favor of the Wünscheltern, overriding the internal rule mater semper certa if the surrogate mother's intention to give birth and free choice are guaranteed in a foreign procedure that complies with the German constitutional law. Verification of the free disposal by the surrogate mothers is therefore a condition. In conclusion, seems to me that Germany typifies a case law under which the changes are very well accepted by appreciating the parental project and the interest of the child. At the same time, imposing a check to prove the presence of a free will. The conclusion that can be drawn is the emergence, alongside biological filiation, adoption, and judicial declaration, of an elective filiation that becomes a new elementary structure for the establishment of a relationship which goes beyond the binary dimension. Such an approach is sharply at odds with one adopted by the Italian courts. Here, in a decision of the 19, the joint division of the the Italian Corte di Cassazione denied registration in a case of surrogacy, calling on the counter limit of public policy based on the protection of the dignity of the pregnant woman as a regulatory balance that cannot be challenged by the court. Italy appears still anchored to a tradition that favors biological factor or, in any case, allow legal rules to prevail, and I am referring to Article 231 of the Italian Civil Code. Nevertheless, a slow change is emerging, echoed in a case law that, for example, allow a woman to have an embryo implanted even after his husband has withdrawn his consent, or that emphasize that it is in the child's best interest to be recognized as the child of those who, and I am quoting the judgment of the Corte Costituzionale of this May of 2025, who have shared the parental commitment through the use of assisted reproduction techniques in accordance with the law, so allowing the registration of a dual maternity to the benefit of the intended mother. Of course, the commitment to the principle of biological paternity-maternity remains very strong in Europe. And even in those legal systems, such as Spain, that have proved to be more open in accepting the relativization as set out in the late runs of the traditional concept of paternity and maternity. The best interest of the child certainly is an important key for the interpretation. But the Spanish experience confirms that differences in interpretation does exist, as it is clear by the debate on how the best interests of the child are best protected. That is, whether by formalizing existing de facto relationship as the constitutional Spanish court believes, or by maintaining a strict moral and legal position against the practice of surrogacy as the Supreme Court believes. This tension is clearly reflected in the instruction of the Directorate General for Legal Security and Public Trust of the last April on updating the registration system for the filiation through surrogacy, which marks a significant tightening of the administrative policy. The recognition of dual maternity but the recognition of dual maternity referred to in Article 7.3 of the LTRHA provides enough support for the legal doctrine to consider intent as an additional basis for the establishment of a parent-child relationship. Nevertheless, generally speaking, in Europe, as said, the importance attributed to intent, the one that in California, since Johnson versus Calvert, 1993, has led to the assertion that the mother is the woman who wanted a child, is hardly accepted. But change is urging, as shows the development in Argentina, for example, of a case law that gives space to the procreational intent and welcomes surrogacy, even if nothing the law says. A good example of this tension can also be found in Germany, which was also influenced by the decision of European Court of Justice in Menesson versus Labasset in Paradiso Campanelli. But the same-sex law passed in 2017 highlighted the need to adopt, or better, to adapt the legislation on filiation. And this need found first answer in a case law that had promptly departed from the exclusion of the Stiefkindadoption for nicht-eheliche Familien on the basis that the equality principle does not allow such interpretation. And so, following the declaration of unconstitutionality referred in the Bundesverfassungsgericht in 2021, asking the legislator to reform paragraph 1592 of the German Civil Code. Now, the reform of filiation, as everybody knows, has been approved last October last year, a move towards the automatic recognition of Mutterzwei based on extension of the presumptive mechanism. The opening to the child's wishes and relationship profile is also confirmed by the tendency to recognize social affectivity when building the parent-child relationship. And in this regard, a pivotal role was played by the judge of the Bundesverfassungsgericht in the judgment of the 9 April 2024 when declaring the unconstitutionality of paragraph 1600 of the German Civil Code. And it is interesting that as a consequence of the role played by the case law, of course, German legislator enacted the Gesetz zur Modernisierung des Familienrechts, recognizing the Verantwortungsgemeinschaft, and so allowing that no more than two people can share that sharing a good relation with parents can take on some parental responsibility, a solution already been adopted by the Argentine judges who stated in a very interesting decision that the treaties and convention do not specify the number of parents that a person may have. That is to say, there is neither specific provision regarding the number of parents to be registered as such, nor rules or guidelines that impose the need to reconcile the regulation established in this regard with international standards. And come to conclusion, as we can see, the winds of change are blowing. A major role played by will and responsibility is in the offing, thus retrieving what Freud had already considered in 1898, namely that elevating the act of procreation to the rank of a voluntary and intentional action, detaching procreation from the idea of satisfying a natural need, would have been a great success for humanity. Thank you.
Thank you very much, Virginia, for this passionate presentation. We have moved from matrimonial properties to establishment of filiation. The next presentation is about same-sex unions and the safeguarding of the economically weaker party. The speaker is Roberta Marino, who is an associate professor of private law at the Department of Economics, Management and Institutions at the University of Naples, Federico II. Roberta, the floor is yours.
Thank you, Professor Bargelli. I want even to thank Professor Francisco Javier Jimenez Munoz. It's the second invitation. I'm very honored to be here. I will share my slides. I hope you can see. Okay. Okay. The issue of same-sex unions and the protection of the economically weaker party following the dissolution of the couple's relationship has given rise to several complex legal questions in Italy. Italian legislation governing relationship between partners has recently modified the limits of the concept of family, as Professor Zambrano said, introducing alongside the institution of marriage and de facto cohabitation, the civil union between persons of the same sex. This institution represents an important turning point in the Italian legal system, as it provides for the first time a framework for regulating unions between persons of the same sex, drawing upon provisions established for marriage. First of all, we can note that the legislative process leading to the current framework has been particularly difficult. Indeed, the present regulation concerning civil union and de facto cohabitation has been introduced by a doctrinal and jurisprudential intense debate. The main stage of this process can be identified in several fundamental rulings of our Constitutional Court and of the European Court of Human Rights. Specifically, the Constitutional Court recognized the same-sex union as a stable cohabitation between two persons of the same sex who are entitled to the fundamental rights to freely live as a couple fall within the scope of our Article 2 of the Italian Constitution. However, according to the court, the recognition of rights and duties for homosexual couples could only be achieved through legislative equalization. It is in the responsibility of Parliament, says the court, in the exercise of his full discretion, to determine the appropriate form of legal protection for such unions. On the basis of this consideration, the Constitutional Court held that the Italian legal framework did not give rise to unreasonable discrimination, since same-sex unions differ from marriage. Marriage institution, says the court in particular, has been inspired by essentially procreative purposes. In the judgment number 170 concerning the effect of a judgment of gender reassignment and its impact on the pre-existing marriage, the Constitutional Court declared the constitutional illegitimacy of the Article 4 of Law number 170 of 1982 that established the so-called imposed divorce in cases where one of the spouses had undergone legal gender reassignment. In the third case, the Oliari and others versus Italy judgment delivered by the European Court of Human Rights, as I say, the court found a violation of Article 8 of the European Convention on Human Rights, which protects family life, insofar as the Italian legal system failed to provide any formal legal protection for same-sex couples. At the same time, however, the court reaffirmed its earlier case law, which has denied the existence of any breach of the Article 12 of the Convention and Article 9 of the Charter of Fundamental Rights. In this way, the court says again that the legislative regulation of marriage and any possible recognition of same-sex marriage falls within the margin of the appreciation reserved to any member states. The indication arrived by the courts were incorporated so in our legal system by the so-called Quirinal law. which in a single article set out the regulation of civil unions and de facto cohabitation. Article 1, paragraph 1 of the law clarified that the state should establish the civil union between persons of the same sex as a specific social formation within the meaning of the Article 2 and 3 of our Italian Constitution, and also governs de facto cohabitation. The definition of a civil union is found in paragraph 2, which provides that two persons of the same sex constitute a civil union by means of a declaration made before a civil register in the presence of two witnesses. Now, I would like to focus on the Article 1, paragraph 11 of Civil law, which specifies the rights and duties arising from a civil union. This provision reveals, in fact, a different from the institution of marriage, since within a civil union, the partner acquired the same rights and the same duties. The union gives rise to a reciprocal obligation of moral and material assistance, as well as to cohabitation. Both partners are required, each in proportion to their own means and capacity to work to contribute to the common needs. It appears evident that the legal framework is modeled upon that of marriage, but there is one notable difference: the obligation of fidelity is absent. In the context of marriage, violation of this duty may lead to a finding of fault in separation proceedings. The substantial overlap instead between civil union and marriage can be observed in certain provisions, such as Article 1, paragraph 11, paragraph 12, and paragraph 30, according to which the property regime of civil union is essentially that of the community of property. But we can identify the most important difference between civil union and marriage. First, a distinction arises with regard to procreation, since marriage, as I said, although not exclusively, has among its purpose that of procreation. This aspect has not a central importance in the context of civil union. Second, there is the absence of the duty, as I said, of fidelity. First, there is no reference to Article 78 of our Civil Code, as the provision concerning affinità, do not apply in the parties of a civil union. Finally, within civil unions, there is no provision such as that found in the Civil Code allowing a legally emancipated minor to enter into marriage. It should be noted that the term cohabitation refers to civil union of two persons who may also be of the same sex, not founded on marriage or a civil union, and characterized by the stability of the relationship and by mutual solidarity. We can find the definition of de facto cohabitation in Article 1, paragraph 37 of the Civil law. A brief analysis of the legislation reveals that law has provided for a series of minimum rights, such as prison visitation, assistance in event of illness, and or hospitalization. On central importance, sorry, I have to go ahead. Okay, sorry. Of central importance for the present analysis is paragraph 50, which regulates the cohabitation agreement. This agreement must be executed in written form under penalty of nullity and may contain provision, among others, specifying the property regime of community or property. The law provides that the cohabitation agreement may also determine the modalities of each party's contribution to the needs of common life. The problematic issue, therefore, lies in determining whether the principle of proportionality set for the Article 170 of our Civil Code, that is a mandatory rule in the context of marriage, can also be applied in this case. The answer appears to be negative insofar the Article 1, paragraph 20 of Syrian law suggests otherwise. As we can see, there is a practical consequences in case of relationship breakdown. The distinction between simple and registry-based cohabitation and contractual cohabitation. This distinction affects both the method of dissolving in the relationship and the possible extension of the rules of maintenance obligation. Concerning the regulation governing the breakdown of the same-sex relation within civil union and de facto cohabitation, we can note that this framework, if compared to the matrimonial model, does not include the institution of legal separation of the Italian civil codes provides in a remedy specific to marriage. Through separation, unlike divorce, the marital status remains unaffected through certain obligations, such therefore those of cohabitation and as I said, fidelity. So we can say that the law for same-sex couples is more light than the one established under Civil Code. Article 1, paragraph 24 of the Civil Law provides that the civil union is dissolved when parties even unilaterally declare their intention to terminate the union before the civil register following the expiration of a 3-month spatium deliberandi, the period of reconsideration. The abandonment of the traditional separation divorce dichotomy typical of marriage take to several consequences. No maintenance allowance is owed according to the Article 156 of Civil Code. There is no fault-based separation. The transformation of the ground for separation is not reasonable. So the regulation of de facto cohabitation also provides for dissolution procedures that are faster even here than those prescribed by our civil code for marriage. Thus, in both cohabitation and civil union, the mechanism of dissolution is more modern and flexible than the one applied to marriage. The central issue concerns the protection of the economically weaker party. Civil unions are governed by a framework that is almost entirely analogous to that of marriage, thanks in part to the express reference made by Article 1, paragraph 25 to the divorce law. Instead, de facto cohabitation must be distinguished between simple and contractual forms. In former case, only an obligation of maintenance is provided for, whereas in the latter, it is considered admissible for the parties to stipulate a maintenance obligation within the contract, the cohabitation agreement. As for civil union between persons of the same sex, in the event of dissolution, the economically weaker partner is entitled to maintenance pursuant according to Article 5 of the law divorce. In this perspective, the analysis of the function and determined criteria for the divorce allowance are very important in the Italian legislation. As we know, this issue has been addressed in 2 judgments of our joint sections of Corte di Cassazione. This decision have evaluated the compensatory and equalizing rather than the only assistential function of the divorce allowance. In particular, the intervention of the joint section of 218 outline a new conception of this institution. So the divorce allowance assumes a compensatory as well as assistential function, since its purpose is to compensate the economically weaker spouse or civil partner for the shared choices and personal sacrifice made during the marriage or civil union that contributed to the family management or to the creation of the couple's joint assets. The courts reaffirmed the fundamental importance of the value of post-marital solidarity and of the divorce allowance, and as an instrument that, within the framework of our Article 29 of our Constitution, performs a balancing function. This function is no longer aimed at the reconstruction of the standard of living enjoyed during the marriage, but rather at recognizing the role and contribution of the economically weaker former spouse or partner to the family life and its economic development. In other words, the function attributed to the divorce allowance is no longer that of enabling the economically weaker party to maintain the standard of living enjoyed during the marriage. Rather, it serves either to provide assistance to the party who lacks the means of self-sufficiency, or offer compensation to the party who can demonstrate that their contribution during the marriage constituted a decisive factor in producing the economic imbalance between spouses. This new predominantly compensatory function has also affected the legal consequences arising from the establishment of a de facto cohabitation. The issue was resolved by joint section of our Court of Cassation on 2021 and is confirmed by later decision of both Supreme Court and the lower courts. This judgment reaffirmed the compensatory function of the divorce allowance and rejected the theory of self-responsibility, according to which each spouse is, at the end of marital relationship, responsible for their own economic self-sufficiency, and any divorce allowance should be limited in a period. As we know, this principle of self-responsibility represents the general rule in many European jurisdictions. This principle is also reflected in the standards elaborated by the Commission on European Family Law. We should know that some scholarship has expressed concern over the fact that Italian law provides for the total loss of the divorce settlement in case where the beneficiary enters into a new marriage. Indeed, if the divorce allowance fulfills the equalizing compensatory function that looks exclusively, let me say, to the past, it must necessarily survive even the beneficiary remarriage, since such remarriage cannot and never could erase the contribution, the sacrifice made during the marital relationship. The equalizing compensatory function is grounded in the principle that the allowance constitutes a right acquired in respect of what has been done in the past. So entering into a new marriage cannot extinguish or invalidate that past. But on the other side, this consideration raises the issue of the dissipation of families' economic resources which are often quite limited and deserving the preservation through the introduction of appropriate balancing measures. Accordingly, some scholars from the Iure Condendo perspective has proposed the introduction of mechanisms that, like to those found in common law system, will give effect to the principle of self-responsibility by establishment of a maintenance allowance which, with assistential and related purpose designed to expire after a reasonable period of time. Thank you.
Thank you very much, Roberta, for this in-depth description of Italian law. There are 6 minutes left for questions, if there is any question from the audience. So please, if there is a question, you can just use the microphone. Please, Gregor. I would have a question as well after you, Gregor. No, you are your microphone.
I think it should be working now. Is that right? Do you hear me? No.
Yes. We can hear you.
Oh, wonderful. Okay, thank you very much for these excellent talks. It's really interesting. So I would have a question for the first speaker, for Sharon. I was interested in reasons why courts prefer shared property over any other regime, because you say that is the general tendency, so they would not apply only the law of the forum or a foreign law. They would generally apply the law that leads them or allows them to apply shared property. So they have a material justice reasoning there. They think that this is the best system. At least I have this impression, and I would be interested in the policy reasons behind such a case law. You said this is the traditional rule in Israel, but maybe there is a bit more to it, and not just this historical reason. And maybe you have some explanations for that. And I would also have a question for Virginia. I found this really interesting because we are also in Austria, we are talking about who is the parent. And recently, like last year, we introduced fertilization, which is no longer artificial, but non-artificial fertilization. So it means that couples, mainly women, can buy or also be given semen that they would then use by themselves, and this would create the two women as parents of the child, and the biological father would not be recognized as a father, but that requires that the two women are either married or in a registered partnership. They cannot just be cohabitants, because if they're cohabitants and they agree to do this, then the father still can recognize. Actually, that is the case. So, but the question is, if you say that for being a parent, it is important to have the intention to be such, and that is in the end what really counts, I wonder what the distinction is, and where do we draw the line between adoption on the one side and this kind of filiation that does no longer depend on biological reasons. Thank you very much.
Okay, so I'll try to be brief. Thank you. It's a very good question, I think. It is not really clear why the judges...
Sharon, may I, because my question would be very much in line with
sure.
Gregor's one. I would like to ask you something more because I was very much impressed by the Nafisi rule, which sounds like a prevalence of substantive law over private international law for reasons connected to substantive justice. And I was wondering where the basis for such prevalence is found according to your jurisdiction. Thank you, and sorry for this interruption.
Yeah, no, thank you. So the Nafisi decision is a complicated one because I think it is not founded in law. So I think the Supreme Court said so, so now it's the law, but I don't think they have good grounds to do that, which is why I am bothered by judges' choice to use it so prevalently and without questions. And I think somewhat connected to the answer to Gregor, I don't think they have a good source to do this. So judges started the tradition of community property and everything goes 50-50. Even though, so we have religious laws here, and this is not part of any of the religious laws. And then we had the civil law regulated, and that is also not the law. But the judges, they have their own preference. I think maybe they've seen too many cases where husbands got away with all the money and they're not happy with it. But it's no longer gendered. It's maybe started gendered. It is no longer the case. But you can see judges interpret facts in a way that doesn't make sense. So you have to think that they have a goal in doing it. And also they interpret laws in a way that doesn't make sense. And you have to think they have a reason. And so my assumption is that they always go, and this is what you see in the outcomes, I think. They always go for community property because they think it's the most just answer. And they also think that the law is not a good barrier. So if they think the law is unjust, they just ignore it, which is just the way they do it. I don't think it's particularly well-founded or within the rules, but this is what they do nonetheless. So it's not a very good answer, but it's the one I have.
That was very good.
Virginia.
Okay, thank you, Gregor. Thank you. I do appreciate your question because, it's interesting. Now, adoption, in my opinion, has worked very well, based on the Roman idea that adoptio natura imitatur. Okay, so that's for sure. But it was a time where technologies had not appeared at all, of course. And the desire to have a child, the desire was in that way satisfied. Now, what we have to take into account is the appearance of the assisted reproductive techniques, and the possibility to have a child based, one likes or no, on the intent. And it's what happened in, just to give you an idea, the Austrian solution found a very well-known way in Brazil, where there is a lot of case law on what they call inseminación casera, just to give you an idea what is going on. But for sure, when adoption was introduced, adoption had the function to work as a substitute for nature. But now with the technology, maybe we have, to switch, to change and to work on categories. And maybe in future, adoption will be less important than was in past. That's also, according to me. I don't know if I answered to your question, but this is my idea. And I think that, it's probably will be the reality in future. What do you think about?
Yeah, thank you very much. I agree, obviously. I just see that there is some possibility that also trafficking of children could be an issue with regard to recognizing such documents that come from foreign countries where it says, this was surrogacy, but we cannot really check it. So I think the German approach that you also talked about is a very good one because it checks
Yes, I
whether
think so.
all the guarantees are there.
Yes.
Otherwise, we're really getting to that, which led at the end to the International Adoption Convention, which actually had the objective of avoiding this problem of trafficking of children.
Exactly.
And if
And we can
now go
Yes,
around it by surrogacy, that would be a problem.
yes. And
Mm.
I think that only if we legalize such a practice, we could just, in a way, solve the problem of trafficking children.
Yeah, I think so too. I just one last question. I do not want to prolong this too much to Sharon, because you said you did not agree with the Nafisi, but if I understand you correctly, this was an Iranian couple that immigrated to Israel, and they were no longer living in Iran, and they had in a way detached from their country because they did not want to live there. Maybe they were also like refugees in Israel. I don't know. It seems so from the narrative that you had that this was in the context of the revolution. I wonder, in private international law, we would generally recognize an escape clause and saying under special circumstances, the general rule should not apply. So we want to apply the law that best fits the situation. So could we not explain Nafisi also in this sense? But then obviously it's not a precedent for all the cases that then followed.
Yeah, thank you. So the court did not see it as an escape clause. So first of all, the rule says the law of their matrimonial property when they married prevails, and they were a Jewish couple, so this would be Jewish law. So it's not a huge problem for them to keep this law, and under Jewish law it would be separation mostly. And so even though, you know, I'm a feminist, but still I think it is, nobody expected for her to get half. And they married and they lived under the assumption that each one keeps their own money. And I don't think it might be sometimes grave injustice, but in this case, she had the family home was co-owned, so it was not like she was going to get out with nothing. And the court really made it in a precedent kind of language, so it looked like a very broad and big case. So of course, I'm not against Mrs. Nafisi. I'm happy for her to get as much as she can, but I feel a little bit bad for Mr. Nafisi, who had no intention of paying all of this. And I also have some concern for the system, because we should have rules that we can expect and understand what is going to happen in the next case. And I can tell you as a fact that when people consult me, I tell them I really don't know. You should make an agreement saying what you want, and then you should pray that the court acknowledge the agreement. So this is not a very good legal practice. So it's absolutely not that I think we can never escape a bad rule, but I think the escape of a bad rule is not deleting all rules altogether. And this is kind of what Nafisi did, which is why I'm a little bit not happy with this case.
Thank you. Thank you to all participants and speakers. I believe there is no further question, and therefore I give the floor to Gregor Kristand, who is a professor of private and comparative private law at the University of Graz, and who will chair the next session as co-chair of the ELI Family and Succession Law Special Interest Group. Thank you very much, Gregor. The floor is yours.